earlier on the news, we told you that Nigeria's former Vice President Yemi Osinbajo was called on the Supreme Court and, of course, the handlers of the judicial system to see to the total overhauling of its legal and judicial philosophy, right, to make it more credible and equitable in the dispense of justice. And we are going to be talking to a legal practitioner who's right here in our studios and be shedding more light on it. I'm talking about Bayo Sanni. Thank you so much, sir, for joining us to discuss this.
Thank you for having me.
All right. So, yeah, so it's been actually argued that rulings based on technicalities has been highly, or should I say, unprecedentedly more pronounced during the 2023 general election, during the tribunals, so to speak. But then when you look at it, including the outcomes of the rulings during the tribunals, how true is that particular stance?
See, this issue of technicality in jurisprudence or judicial, legal system is not limited to election petition tribunals alone. It's a general clog in the wheel of justice in Nigeria today. And unfortunately, some of these technicalities were placed there by law, statutes or enactment that ought to have been amended based on modern realities. And some were introduced in recent time by the lawmakers, you understand, thereby denying the people access to justice. So, back to your question, how true? It's very true. But I want to add that it's not limited to election petition or election matters only. It's a general problem.
So some have actually described that the tribunal's adjudication during that period was like a judicial heist. So from what you're saying now, you're making it look as though there was a deliberate attempt to include some certain clauses or some laws to circumvent justice being served after the expiration of the electoral cycle.
You see, those laws, no, I wouldn't agree with that position, that those laws were deliberately inserted to circumvent justice. No. Some of them were inadvertently placed there. Some were abused to achieve certain purposes. But some were placed there for the general interest of the masses in good faith, but later probably abused or manipulated to suit other purposes. And some, look, when we talk about these things, we shouldn't also exonerate legal practitioners. Sometimes these technical issues are not, sometimes they are not always a problem. They're not always a clog in the wheel of justice. Some of them are also placed there for us to have decorum in our legal system. However, when we are talking about judiciary, we should also address the main stakeholder, which are the legal practitioners. We will understand that this is the position of the law with respect to this procedure, and we still go ahead and do the wrong thing. Now, they will now play back to the gallery of the masses that look at what is happening in the judicial system. So let us balance this discourse. Let us look at it from the judicial angle, and let us also look at it from the angle of the bar.
So is it a case of bad eggs in the system, or is a total systemic failure?
Not total systemic failure. Bad eggs in the system would be more appropriate. Bad eggs in the system. But let us now, coming back to the main issue, is that some of these laws should have been amended. Some of these laws that raises these technicalities in our legal system should have been amended. You know, if you look at it, for example, let us come down to the issue of the evidence now. When Evidence Act was drafted, there was no Zoom, no virtual system. The extant evidence law we have in Nigeria is Evidence Act 2011. When Evidence Act 2011 came into operation, nothing like Zoom, nothing like virtual. virtual system came up after the pandemic, when people realized that, oh, a lot of businesses can be conducted virtually. Whereas Evidence Act provided that you must appear before a commissioner for oath to depose to an affidavit. Why can't we amend the law to accommodate that situation? Why? Same for this election matter that you have explained now. We know that in those days, appellate matter, appeal on electoral petition used to terminate at the Court of Appeal. Later, the electoral law was amended to allow them to go to the Supreme Court. Then there is a time frame for you to conclude this process. I mean, that means the whole process must be concluded within a particular time frame. Yeah. If you don't conclude, automatically, Supreme Court will throw your case out. There are pre-election matters, there are post-election matters.
Okay, so basically it's a whole lot to deal with.
It is a whole lot.
Okay, we are going to come back to the conversation now, most especially you talked about reforms, but then let's quickly go on a break, and when we return, we'll conclude with this on the news. Do stay with us. We're still on the news, and we're just still touching on the issue around the call for a total overhaul of Nigeria's judicial philosophy, according to Nigeria's former Vice President Yemi Osinbajo. And I have a legal luminary who's right here in our studio, of course, Bayo Sanni. He's been sharing his thoughts with us. So even as we quickly conclude on this, we hear of political interference by the political top shots. Of course, the legislature is also there in terms of the role they play, their interference, and of course the executive arm also. How do all these affect the efficacy of the processes that judges should sit on?
You see, if we don't practice proper democracy, we will always have this problem. What do I mean? If we don't try as much as possible to uphold the principles of democracy, we will always come to this issue by respecting the Constitution, respecting the principle of separation of powers, and respecting the principle of law. Now, you mentioned the third arm, the second arm of government, which is the legislature. They play a prominent role. It is the law made by these lawmakers that judiciary will interpret, save when judiciary is making law under case law. But of course, most enactments comes from the House of Assembly. Some of them should have been reviewed and amended. But you see, when we have House of Assembly, I don't know, I don't want to cast any aspersion here, but like it's a wake-up call. It's a wake-up call.
What sort of reforms do we need? Either it's going to be championed or channeled or ratified by any of the arms of government to actually make our judicial system credible.
The kind of reform we need, first and foremost, is to look at the instrument that created this very arm of government, which is the Constitution. That is our first point of call. How independent is the judiciary under the Constitution? Do we have provisions that assure us of their independence? Look at the fiscal policy. Most judiciary under the state, most judges at the state level are still acting as if they are commissioners of the governor. Do you understand? So when we look at that instrument, which is the ground norm here, that created that arm of government, then we look at all the lacunas in this instrument and amend it or create provisions that will enable the judiciary to perform. That is where the legislature has a major role to play, critical role to play. But how willing are they to even play this role? Some of them are looking at it that, oh, I'll be governor someday. Don't let us don't let us remove the grip we have on the judiciary because I'm eyeing the position. That is not how to run a country. And that is not, a system of government that is looking at younger generations. Looking at the future. That let us put things right now. The mistake we made in 1999, we are still running about it, and we are still suffering for it today. Do you understand? So, if we handle that from the angle of the legislature, let us now come back to the judiciary itself. apart from the laws, apart from the statutory provisions, judiciary has what we call rules of court that regulates their procedures. Let us also look into this. The rules of court are clearly within the powers of the Chief Justice of Nigeria and the Chief Judges of each state to make the rules for their court. And if there is a lacuna in the law, you can easily cure some of it by the rules, not making it inconsistent with the law, but modifying it to suit the modern reality.
Of course. So we are talking about influences on the part of the judicial system. Of course, we're still talking about the need for the electoral umpire to also be autonomous. But then the question will always be, like you said, who will actually bail the cats? That is the million-dollar question. Thank you so much, of course, Bayo Sanni, for sharing your thoughts with us on the news. It was nice having you around.
Thank you very much.